Very happy Wednesday, August 14th to you. I'm Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be your moderator for today's Elville webinar series presentation. Our topic today is Estate Planning Essentials, presented by Elville & Associates Senior Associate Attorney and Estate Planning Team Leader, Shannon Werbeck. And you're in the right place for high-level legal education today. We have several new attendees on our webinar today, so welcome to one and all. So a couple of housekeeping items as well. We always encourage your general questions throughout, so please post them in the chat or the questions section on your panel there, and we'll pause periodically to address them. And your questions always are a great help to the presentation. And yesterday by email, you received the presentation slides that Shannon will be referencing, and these slides are also available in the section marked handouts in the panel on your screen to download at this time. And for our professionals on today's webinar, welcome to you as well, and thanks for being here. As is the case with most every one of our presentations, 1.5 continuing education hours are available for most everyone in attendance. So if I don't have your ID number or an accreditation you'd like to have added to a certificate of attendance, please send that to me so I can submit your hours for approval. And everyone will also receive a post-webinar feedback email right after the presentation, so please take just a minute or two to fill out this very simple yet important survey for us and offer us your thoughts about the presentation. And here at Elville & Associates, we're always here as a resource for your family and you, whether that's new planning that needs to be addressed, old outdated documents that need to be updated, which we see all the time, or perhaps another matter. Shannon and our team here are here to advise and counsel you every step of the way here in our Columbia office, our new Rockville office, our Annapolis office, or another way, perhaps by video if you prefer. So I'd like to share with you just a bit about the firm and Shannon, and we're going to jump right into the presentation. So what makes us different as opposed to all those other law firms that you may have worked with before, or perhaps the dozens of webinars that you've been on in the past with other organizations? Well, Elville & Associates, we have a focus on education here and high-level client counseling, founded in 2010 in Columbia by Stephen Elville. We do focus on several different practice areas, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection, which falls under the umbrella of estate planning and elder law. We have 9 attorneys, including our counsel attorneys, 12 staff members in 3 locations. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. As I said, we focus a lot on education here for our clients and the communities that we serve, and we do that in many different ways. A few of those are through our planning processes with our clients. We have programs here to suit any individual and family, so we encourage you to come in and check us out if you haven't done so already. We also have, as you know, many educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program, we're one of only a couple firms in Maryland to have a client care program that's fully accredited by the Client Care Academy in Boston. And we also focus on the ideals of client education, collaboration, and compassion with every client every day here at Elville & Associates. Just a bit about Shannon. Her work as an attorney has been centered in estate planning along with assisting clients with special needs planning and elder law matters. She is a University of Baltimore School of Law graduate and was admitted to the Maryland State Bar in 2020 and is a member of the Maryland State Bar Association. And Shannon educates and counsels clients throughout the entire estate planning process, starting with that very important initial consultation, followed by the design and implementation of their plans, as well as the necessary maintenance and updating. And who likes maintenance and updating? Well, we do here at Elville & Associates. We're going to encourage you to do that as well. So that's maintenance and updating of their plans as you have changes in your lives and changes in law over time. And lastly, Shannon was named and nominated by her peers to the Rising Stars list of Maryland Super Lawyers for the first time in 2023. And again in 2024, we'll see what 2025 brings in the next few months or so. So welcome, Shannon, and welcome to all of our attendees. I'm going to go ahead and turn the screen over to you and make you the presenter, and we'll get started.
All right, perfect. Jeff, does this look okay on your end?
Go to your display settings there up at the top there. That looks great. Yep.
Okay. Give me 1 second, Jeff. I'm going to stop showing my screen for a second because I just have to fix something on my end. Okay. How about now, Jeff?
Looks great. Yep.
Perfect. All right.
Okay,
Hello, everyone.
thanks.
Thank you for joining us here today. As Jeff stated, my name is Shannon Werbeck. I am an attorney with Elville and Associates. And I work with clients through the estate planning process, developing their estate plan based on their goals and intentions and needs, educate them through the entire estate planning process so they have a full understanding of their estate planning documents up until the implementation of their plan. And of course, as Jeff mentioned, the continued updating and maintenance of their plan, which is very important throughout their lives. So let's get started here today. I'm going to be presenting on the essentials of estate planning. So just a brief disclaimer before I get started. The following presentation is really meant just for educational purposes only. It's not intended as, nor can it be construed as legal advice. So we're not developing an attorney-client relationship here today. But, you know, I'm happy to develop one in the future to help you develop your estate plan. Okay, so our goals for this morning are, you know, to discuss what exactly is an estate plan, what does the process consist of developing an estate plan, why some estate plans actually fail, and what you yourself can do to avoid planning failure. We'll discuss a last will and testament versus a revocable living trust. Those are two very common estate planning tools. And we'll discuss the probate and non-probate concepts and to give you an understanding of that. And then we'll talk about how you yourself can get started. What are next steps now after this presentation to update your estate plan or to get started on actually creating and designing an estate plan? Okay, so we're going to start with understanding the estate planning process. We'll dive into why you should plan. We'll dive into the two different types of traditional and educational estate planning approaches and which one Elville and Associates utilizes to really make sure that your plan is successful. So first, let's start with why plan? Why put a plan in place? Well, there's many different reasons why you should plan. And here are just a few here that are very important. So it's important to plan to provide certainty for your loved ones. Make sure that everything is in place so that upon your death, they don't need to worry. They just need to look at what you already have in place, and it'll in turn facilitate a smooth administration of your estate. To minimize costs of administration, to protect assets for your loved ones. An example of this is maybe you have a loved one with special needs who is applying for in the future or receiving needs-based governmental benefits, and we want to make sure the distribution you leave them doesn't disrupt their benefits. There's ways to plan for that. There's certain estate planning tools that can be utilized to make sure that their distribution goes to them in a way as to not disrupt their governmental benefits. So that's just a brief example. We plan to minimize taxes, to achieve your special purpose, and to attain your estate planning goals. So there are two major types of estate planning. There's the traditional estate planning approach, and there is the educational estate planning approach. And in the next two slides, I'm going to be talking about what each of those entails and what approach Elville and Associates utilizes. So let's start with the traditional estate planning approach. So the traditional estate planning approach, it's really limited to one planning phase. There's typically no educational component to it. It's strictly just a document transaction. The documents themselves are what the plan is. So you may meet with an attorney initially, and they will maybe discuss your estate planning needs, but then they'll probably prepare the documents, maybe send it to you to review once, and then you come in and just sign your plan. So there's typically no maintenance or updating, and as a result, the average client, typically really just revisits their planning approximately every 19 years, which is a pretty long time, and that really leads to a high likelihood that your plan will fail. So in this type of estate planning approach, clients are typically never contacted again by the firm or the attorney, and it really leads again to the failure of your plan. So next, let's talk about a different estate planning approach, which is an approach that Elville and Associates utilizes, which is the educational estate planning approach. So the educational estate planning approach incorporates three major phases of planning. The first phase is the design and implementation of the plan. So through the design process, there's really an emphasis on education. You meet with an attorney initially at our firm who, talks about, your different goals and intentions for your estate plan, what your current life circumstance is, gets a financial and asset picture, and then designs a plan that's best for you to meet your estate planning goals based off that conversation. And then we go through a series of meetings to really review your documents with you. Again, emphasis on education. Make sure you have a full understanding of your documents. And then, of course, there's the implementation of the plan, actually signing the plan into effect. And then number two is very important, maintaining and updating your plan. Simply signing your plan into effect and saying, I'm done, I'm putting it to the side, I don't need to do anything else, I'm all set, is great in theory, but for a successful estate plan, it's really a life process. It's process driven. So we recommend, depending on your age and where you're at in your life, if you're on the younger end, you really look to updating your estate plan every 5 to 7 years. As you get up there in age, start looking at your plan every 3 to 5 years. And then as you get, even up there in age, looking at your plan every 1 to 3 years. Maryland law is forever changing. Our lives are forever changing. If there's, a situation that occurs in your life, it's best to relook at your plan, a big change in your life. So we just want to make sure that your intentions and goals are met based on where you are at what stage in your life. And then 3 is the final administration of the plan, which is, unfortunately, you've passed away and your whoever you've named to administer your plan does so, hopefully in a very streamlined way, because hopefully you've maintained your plan throughout your life, and it makes it easier on the end of who's administering your estate or your trust at that time. With an educational estate planning approach, there is regular client contact, which really contributes to the plan, especially our firm, who sends out, alerts to client if there's big changes in Maryland law, and just kind of reminds clients to really update their estate planning. So we've talked about what the two estate planning approaches are, but what is estate planning in itself? So estate planning is a comprehensive analysis of your goals, your risk to tolerance, where you are in your life stage, your family, health, and personal circumstances at the time. And then taking into account your financial and asset picture, all to produce suitable legal documents, and in turn achieves your estate planning goals. So I want to do a brief overview in general of estate planning, because many times I have clients, potential clients who I meet with, who want to talk about what happens with their assets and their property at death, what the distribution of their assets will look like. And that is, of course, very important. But what's equally as important, and what some people forget, is planning while you're still alive. And that's what I call incapacity planning. God forbid you become incapacitated, naming somebody to make healthcare decisions for you, or financial decisions for you. And we'll get further into incapacity planning and dive deeper into that in upcoming slides. But just a brief review of estate planning. It's planning for the care of your health and property and assets while you are alive, particularly in the event you become incapacitated, and planning for the disposition of your property at death, and for the protection and care of those who are dependent upon you. So simply put, having the necessary legal documents to dictate who will handle things for you if you're unable to do so yourself, again, typically due to incapacity or death, and how they will handle things for you. So let's start by talking about a will-based estate plan. So the fundamental estate planning documents include a last will and testament and incapacity planning. So you will see the will in the middle. It is the driving force for the plan. And then you have that advanced medical directive and power of attorney documents, as well as something called a most form, which I'll hit on in a later slide and briefly mention. But these documents, they are the fundamental estate planning documents, the documents that you should at least have in place if you are doing estate planning. Okay, so let's dive into the last will and testament. So a last will and testament is a document that dictates what you want to happen with your assets and your property at death, as well as who you want to handle your affairs. So that person who you want to handle your affairs, who you're designating in your last will and testament, is known as the personal representative. Some clients know it as the executor of the will. In other states, it is called the executor, but in Maryland, particularly, we call it a personal representative. That's the term we use. So in order for a said asset to go from a deceased individual owner to the person meant to inherit the asset, it has to go through what is called probate. So probate is where the last will and testament is relevant, and it is a court process which has to take place when there is an asset with no living owner. So if probate occurs, the court will inquire as to whether the decedent has a last will and testament, which the court will rely on when administering the probate estate. So through this process, your documents are open to the public eye to view at any time. So when your last will and testament is filed with the probate court, anyone off the street can pretty much come in and review your last will and testament and your estate planning documents. I don't know that many people know that they can do that, but it's just something that you should know. Sometimes people specifically maybe disinherit someone and they don't want somebody to be able to go in and review their last will and testament. So let's talk about the administration process with a last will and testament. So the probate process can take up to 9 months, sometimes more, really depending on the size of the estate. It involves opening an estate with the Register of Wills office, the probate process, which includes the filing of an inventory report, and the inventory report outlines what assets are part of the probate estate. There's about a 6-month creditor period, which allows potential creditors to make claims against your estate if you owe them money, as well as filing an accounting to display to the Register of Wills office what is taking place inside the estate. So sometimes you can get away with just a first and final accounting, but there are times where multiple accountings may need to be filed. There are also costs associated with probate. The primary cost is made up of payments to the probate court, really to process your documents, having to pay for maybe a professional to assist in filing final tax returns, and even attaining the assistance of an attorney to assist with the probate process. The average cost of probate is about 4 to 7% of the probate assets. So we talked about a last will and testament, how it's associated with a process called probate, and that your will is what dictates how your assets and your property flow and to who upon your death. So there are assets actually that do not go through probate, and they're called non-probate assets. So if something is jointly owned, it does not go through probate. So maybe you're listed on as a married couple on a deed as tenants by the entirety with rights of survivorship. So you own that jointly with somebody. That doesn't go through probate. Or joint owners on a bank account. There's beneficiary designations. The main types of commonly known beneficiary designations are a retirement plan or life insurance. Those have beneficiary designations on them. There's payable upon death designations, which typically can be linked to a bank account. There's transfer on death designations, which some people put on the ownership of their car title. And then there's interest for accounts. So let's talk about how these non-probate assets actually transfer. And it doesn't matter if you have a will or a trust. If anything is listed in this way, this is how it'll transfer. So for a joint ownership account, it'll pass to, or joint ownership property, it'll pass to the surviving joint owner. For a payable upon death designation or a transferable upon death designation, it'll pass to the beneficiary. For beneficiary designations, again, a retirement plan account, life insurance, and annuity, it'll pass to a beneficiary. And then in trust for accounts also pass to a beneficiary. So let's dive into another estate planning tool, which is the revocable living trust. A revocable living trust is a substitute to a last will and testament. It is a private document. I like to think of it as a contract that you have with yourself. You are what's called the grantor of the revocable living trust, meaning you are the creator of the trust, and you pay the taxes for the assets that are within the trust, and you are also the trustee, the person who manages the trust assets. So you have a contract with yourself as the grantor, with yourself as the trustee. So a revocable living trust, I call it a substitute to a last will and testament because it takes the place of a last will and testament, and it also avoids probate. So when I have clients who, or potential clients who I meet with who let me know that they're motivated to avoid probate, maybe they have an aversion to probate based on if they were a personal representative for somebody's estate in the past, or maybe even a beneficiary and things didn't go so well. When they tell me that their goal really is to avoid probate, then I start talking to them about a revocable living trust plan. So some people think simply just signing a revocable living trust is what avoids probate. And unfortunately, there's more work to be done after that. You can't just simply sign the document and it avoids probate. The next step is to go through a funding process, which is aligning your assets to your trust. So changing the ownership on some of your accounts to from you as the owner to you as the trustee of your trust. If you have a real property, any property you have actually, we would change the ownership on those on the deed to you as the sole owner, to you as the trustee of your trust. That way, upon your death, your assets can be distributed privately and without the court's involvement. So there is a common misconception that a revocable living trust provides creditor protection or asset protection, or that there's tax saving advantages to a revocable living trust. And that's simply, unfortunately, just not true. What it actually does is it just is an estate planning tool that's a private document. It doesn't get filed with the Register of Wills office, and it avoids the probate process. There would have to be an administration, a trust administration in place to administer your trust assets upon your death. And the average cost for a revocable living trust is about 1 to 2%. And I will tell you that a revocable living trust, it is, a more costly option because, it is a more complex document. There's more work and cost up front. So in turn, upon your death, there's less cost and work to be done. So let's dive into what a revocable living trust structure looks like. So here is the revocable living trust structure. You'll see that the revocable living trust is in the middle. It's the driving force for the estate plan. You'll see that there's 2 documents in there that you saw in the will-based structure, which is that advanced medical directive and financial power of attorney document. And then you'll see there's 2 other documents here that were not listed in the last will and testament based structure. So there's the pour over will. And the way I think of a pour over will is a safety net document. So remember, with a revocable living trust, we align your assets to your trust so that upon your death, your assets can be distributed privately and without the court's involvement. So it avoids that probate process. But, what if something slips through the cracks? Now, on our end, we do everything possible to try and make sure that your assets are all aligned to your trust. But what if later on down the line, you buy a new property, you open a new bank account, and that doesn't get aligned to the trust? So what would actually have to happen upon your death is that asset or property would have to go through probate, unfortunately. But we've created this safety net document, a pour-over will, which is a very standard, simple last will and testament that would be filed with the probate court, which would dictate to the Register of Wills office that after that asset or property goes through probate, it'll pour over into your revocable trust and be distributed by your trust terms. So your trust will still designate how your distributions are made upon your death. Unfortunately, it would just have to go through probate first for that asset or property that doesn't get aligned to your trust. And then there's the assignments. We have you sign, it's a one-page document for an assignment of what's called tangible personal property and an assignment of intangible personal property. So an assignment of tangible personal property is, the way I describe it, is really just the items within your home, and you're signing a document stating that you're aligning those to your trust. And then there's assignment of intangible personal property, which means if you get a tax return, for example, or if you get paid back from a loan or paid back on a note, that would automatically be assigned to your revocable trust. Jeff, I'm going to pause. Do we have any questions?
Thanks, Shannon. No questions as of yet.
No
I'm
worries.
sure they're coming now.
Okay, perfect. Okay, so next I want to talk understanding incapacity planning. So we talked about how having incapacity planning documents is very important in your estate planning structure. You saw it in the will-based structure, and you also saw it in the trust-based structure. So incapacity planning is the planning for the care of your health and property, particularly in the event you are to become incapacitated. So they are life-based documents. There's the financial power of attorney document, there's the advanced medical directive, and there's the MOLST form, the medical orders for life-sustaining treatment form, which I will dive into a little bit as well. Okay, so incapacity planning. Again, there's the advanced medical directive, and there's the power of attorney documents. You'll see there's 2 power of attorney documents listed there, and I will talk about why our firm utilizes those two documents in the next slide. But first, let's talk about what the main purpose is for incapacity planning. So one of the main purposes of incapacity planning is that these 3 documents, they avoid something called guardianship. So people are often familiar with the term guardianship as it applies to their minor children, meaning if I die before my child reaches the age of 18, which is the age of maturity under the law, who will be my child's guardian? So there is another type of guardianship, which is for an adult. So specifically guardianship of a disabled adult, which is relevant in the event there is an adult who is over the age of 18 and who loses their mental capacity and who has unfortunately not signed documents in place designating an agent to have authority to act on their behalf. So if this were to occur, it would unfortunately become necessary for an individual to seek a court-ordered guardianship over the incapacitated adult in order to make decisions on their behalf in regard to their health and management of their assets. So it's important to sign the necessary documents while you still have mental capacity to designate agents and be able to outline specifics about your health care and what powers and authorities your agents have in regard to your assets. And by signing these documents in place, you are maintaining autonomy in the event you actually lose your capacity and you lose the ability to make decisions for yourself. So guardianship, unfortunately, it really strips you of your rights. And so an advanced medical directive and financial power of attorney documents are really a least restrictive mean to guardianship. Okay, next I want to talk about the financial power of attorney documents. Our firm utilizes a two-tiered approach. We utilize two powers of attorney documents, the statutory financial power of attorney document, along with the general durable power of attorney document. So financial power of attorney documents are only valid while you are alive, and they are documents that allow you to name another individual to have authority to access your bank accounts, deal with your 401k, continue paying your bills, pay your taxes, manage your property, your house, and essentially any of your assets. So in order for someone who is not an owner of an asset to have access and be able to do what needs to be done with that asset, there needs to be a financial power of attorney put in place. So your power of attorney, they really have a fiduciary duty, which means that they are to act in your best interest and for your benefit. And again, at Elville and Associates, we provide two documents that constitute and cover all of your bases regarding a financial power of attorney. So there's the Maryland Statutory Financial Power of Attorney document. The Maryland Statutory Financial Power of Attorney document is written directly into Maryland statute. In the statute, it actually states that if this form is used and you do not change the writing within the document, except for a few authorized provisions, that it's mandatory that banks and other financial institutions accept it. So it is an extremely powerful document, but it's very limited in what we can customize. It is the smaller of the two power of attorney documents, and that it really just lists what the average person has. So it is a limited list, but it really does typically cover about 98 to 99% of what people have. The second power of attorney document our firm recommends and provides is the general durable power of attorney document. This document is essentially a supplement to the Maryland statutory power of attorney document. Although the Maryland statutory financial power of attorney document covers most circumstances, there are unfortunately some circumstances that it does not cover. Because remember, it really just covers what the average person has. So the general durable power of attorney document, it includes the same agents as the Maryland statutory power of attorney document because we really want to make sure that it's consistent. However, it's a more comprehensive document and it includes additional provisions and powers to ensure that all bases are covered. So it really ensures that your agent does not run into any obstacles in the event they need to act on your behalf and has enough flexibility in accessing your assets. So here are some of the the enhanced powers in the general durable power of attorney document. There's the power to establish revocable and irrevocable trusts on your behalf. There's the power to fund trusts. There's the power to change beneficiary designations on your accounts. There's enhanced powers to manage digital assets. There's the power to perform a Medicaid spend down of your assets for you to qualify for Medicaid in the event maybe you need to go into skilled nursing care in the future. There's power to care for and deal with your pets, to provide housing support and maintenance for them, provide for their veterinary care. There's the power to customize, powers to gift assets to your beneficiaries. There's the power to manage and receive compensation. So sometimes being somebody's power of attorney can be a full-time job, and we really don't want somebody to quit being your power of attorney because They're losing out on hourly wages from work, so this allows them to receive reasonable compensation if that is the case, so that they'll continue on being your power of attorney. And then there's the power to operate a business or manage an interest in a partnership or an LLC, if that's applicable to you.
Shannon, can we pause for a question?
Absolutely.
All right. Question is, I have a minor child on the autism spectrum. What power of attorney would be recommended for both parents to be able to make decisions on his behalf when he turns 18?
So that is a great question, and it really comes down to meeting with an attorney to discuss the parameters around your child's autism diagnosis, if they really have the ability to understand an advanced medical directive and financial power of attorney document. Not to say they have to understand every word of it, but understand that, your parents are going to continue, helping you make healthcare decisions, continue helping you with your money. And if they're unable to have just a basic understanding of that, because, the autism spectrum, it is very broad, it's large, and it just depends where they are on the spectrum. So if they are unable to understand those types of documents, then it's a good idea to start talking about guardianship, so becoming the guardian of their person and property. So it really is just dependent on your circumstances and where your child is at. And that's why it's great to have an initial consultation to discuss that further and discuss whether you believe, which approach would be better. Okay, any other questions, Jeff?
Not right now, thanks, Shannon.
Okay, perfect. All right, so next I want to dive into the Advanced Medical Directive. So in Maryland, the document covering healthcare decisions in the event you become incapacitated is called the Advanced Medical Directive. And the Advanced Medical Directive, it includes a section that people are often familiar with, which is the living will, but it also includes other sections as well. So the first section really dives into naming an agent to make healthcare decisions on your behalf in the event you're unable to do so yourself due to incapacity. And then the second section is what dives into that living will. So the living will allows an individual to provide instructions regarding healthcare treatment in certain end-of-life situations. So in Maryland, this section is broken up into 3 distinct categories. There is preference in case of a terminal condition, preference in case of a persistent vegetative state, and preference in case of an end-stage condition. So the Advanced Medical Directive, it actually doesn't just dive into clinical aspects of things, but it also includes what your personal preferences are. For example, do you want certain music to be played during the end of your life? Some people say, I don't want the television playing. I've had people say they want their pet to be there if possible. They'd prefer to pass away at home. I want my family and friends to be there if possible. I've had individuals state, they're, religious and they want a priest to come in and read them their last rites, or their pastor to come in and visit them. So the Advanced Medical Directive allows you to incorporate those types of personal preferences within the document. There's also flexibility options built into the Advanced Medical Directive. So Maryland actually allows you to state that, these are your instructions, but maybe that this is just a guide for your agent. So you're giving your healthcare agent the discretion to make a different decision in the moment if they believe it's in your best interest. Or you can choose to say that they don't have discretion and that they are to follow your instructions exactly. And then finally, the Advanced Medical Directive, the third part of the Advanced Medical Directive, allows you to dictate your organ donation preferences and your preferences regarding your final arrangements. So for many people, this section and the end of life preferences is really not something they've spent a significant amount of time thinking about, and it can become, uncomfortable for them to discuss. But it is really healthy that it's something you haven't spent a significant amount of time thinking about. You shouldn't be, thinking about this every day, but it is good to think about it at least just for a bit of time to have a peace of mind that in the event something does occur, things are really put in place for you. Your preferences are laid out, and that your intentions will be met based on your preferences. Okay, so I want to talk a little bit about the MOST form. So this is the Medical Orders for Life-Sustaining Treatments form. A lot of people call this the DNR document. Now, the Do Not Resuscitate document. Now, this document is actually not prepared by an attorney. It has, very technical medical terminology, and we are not medical professionals, so we really cannot advise you about the MOST form and the medical technicalities within it. So often this is given to you by your doctor to complete. We do have this form in our office that we can provide to you. Again, we can't counsel you through it, but we can provide it to you for you to bring to maybe your primary care doctor and have this filled out ahead of time. Because, say you go into the hospital for a surgery, say you need to go into skilled nursing care, or you want to go into assisted living, they typically require this form to be done ahead of time. So it is an important form. It does go into DNR and really the nitty-gritties of your end-of-life choices. But it is, again, a document that we cannot advise on because we are not medical professionals, but it is a document that we highly recommend you also have in place for incapacity planning. So now I want to talk about our Elville and Associates Client Care Program, because this is another great tool to make sure that your plan is successful. It allows for many different membership benefits. And what I'm going to do actually is turn this over to Jeff to discuss, because he actually is our client care coordinator, and he can provide a more detailed list of what your membership benefits are. So Jeff, I'm going to let you discuss this part of the presentation.
Sure, thanks, Shannon. So I'm fortunate to be the director of our client care program, and really, I think the primary goal and purpose of the client care program is to ensure that your plan is maintained and updated each year. So there is a membership fee involved in it, but there's a lot of things that come with it. And one of the things that a lot of our members find most valuable is an annual review of their plan with an attorney here at the firm. And so the client care program encourages reviews each year. 2 hours of attorney time is included in your membership each year, which is very valuable. We offer lots of different webinars here, as you know, and presentations. We also provide quarterly workshops that are only for members of the client care program, along with their families. And we also offer a nice social event each year. We're going to see the Orioles in about 3 weeks or so. And it's really the highest and best form of partnership with the firm to ensure that your planning is going to work, as Shannon's talked about, going to work as intended over now and over the course of your lifetime. And other benefits that Shannon's showing here, an annual review of your asset alignment, making sure that your trust is funded properly on an ongoing basis, a family meeting, which a lot of clients find really important. We also offer discounts on deed preparation and also services to programs like DocuBank and EverPlans, which are really good financial tools that can help you keep your finances in order. And also that DocuBank is a tool that should you ever need to go into the hospital, God forbid, your healthcare directive, your advanced directive will be on file so that with just a quick code, people at the hospital can pull that advanced directive along with your agent. They can have it in their hands, so they'll know what to do in case of an emergency type situation. So I'm very happy to speak further with anybody about the client care program at any time in more depth. And it's a recurring yearly membership, and we typically set those up and renew memberships starting in December or so of each year. But anybody can join at any time on a prorated basis as well. So happy to talk further with you about it.
Perfect. Thank you so much, Jeff.
My pleasure.
And again, any other further questions about the client care program, absolutely reach out to our firm to discuss. Again, I highly recommend joining the client care program. It is a great tool to make sure that your planning is successful in the long run. Okay, so let's talk about a path forward. We've talked about the essentials of estate planning. What can you do next to either start an estate plan, put one in place, or update your estate plan? So I highly recommend scheduling a consultation with Elville and Associates with an attorney at our firm. Complete an estate planning questionnaire that we'll send to you, which is just basic information about yourself and your assets, which can give us a better idea in the actual initial consultation on designing a plan for you. You know, bring your current estate planning documents, you know, in for a complete review. We've had, you know, clients bring, you know, documents in that maybe even we've done that are older, or we've had clients bring in documents that are from other firms, and we can do a review of the documents and, you know, maybe design a new plan or update the plan based on your current life stage, your current life circumstances, your current intentions and goals. I highly recommend you prepare any questions or concerns you may have for the discussion and bring them in. And really take time to think, you know, decide what is important to you and what your actual estate planning goals are. I know that it can be uncomfortable for some people to talk about estate planning, especially incapacity planning. And I just want you to know that, you know, you can relax. There really is nothing to fear. There's just information to be gained. So thank you so much, everybody, for joining us today to talk about the essentials of estate planning. You'll see here our firm's phone number, my email address, and Jeff's email address for if you have any further questions after this presentation. If you want to schedule an initial consultation, we do offer a free 1-hour initial consultation. So there really just is information to be gained from it. If you have, again, any other questions, please contact myself or Jeff at the phone number and addresses provided. And I hope everyone has a lovely day. It's almost the weekend, almost Friday. So, you know, get out there. The weather looks very nice out. It seems like it's cooled down a bit. So have a great rest of your week and a great weekend. And if anybody has any other questions, please feel free to get them in now, and I will turn us over to Jeff.
Thanks, Shannon. You're reading my mind. Now would be a great time to get those final questions into Shannon, and we do have one to start with. And the question is, any guidelines about how to select an administrator? I'm assuming meaning a personal representative.
Right, so you really want to choose a personal representative who you trust, or, you know, maybe a personal representative who may have experience in administering an estate, or maybe experience dealing with assets. Now, that to say, there's a lot of people who don't have that experience. We've had people, you know, name a family member or friend, which people typically do, and, you know, they hire an attorney to help with that process. We do have an estate and trust administration department at our firm who guides individuals, personal representatives, through that estate planning process. There are some people who decide to name a corporate fiduciary as their personal representative, either a law firm, maybe a financial advisor, or a CPA. And just keep in mind with that, that's a great idea because they do have experience, but it does, come with a cost. You'll have to pay their fees for that. So most of the time, people do just name a family member or a friend to be the personal representative of their estate. And we do have you name backup personal representatives in the event the person you named is unable or unwilling to serve. So again, highly recommend you just really choose somebody you trust to act in that role.
Thanks, Shannon. I'll just say I was a personal representative on one of my relatives' estates who passed away a couple of years ago, and it can be a daunting task.
Mm-hmm.
And having a full-time job and working with the charity and having a family of my own, there's a lot to understand in that process. And so I know some people do it alone, but I enlisted the help of our attorneys here at the firm who kept us on track and met all the deadlines that are required through the probate process because it was a probate estate.
Mm-hmm.
And it was just gave me a lot of peace of mind. So there's different paths you can take, but selecting the right personal representative is the first step, and then lots of different processes to go forward after that. So let us know if we can help you with a need like that when the situation arises. Always happy to be a resource.
Absolutely.
And no other questions as of now, so I'll just say a couple things. So thank you again, Shannon, for a great presentation, to our attendees for being here and your interest in our webinar series in our firm. And as always, I'll send out today's video and the slides for your review. I know you'll watch this a couple of times to take it all in. And I'll send out some information about our MOLST, which I typically do after this essentials presentation. And as for our upcoming schedule with our webinar series, lo and behold, next Wednesday, the 21st, with Steve Elville, Understanding Estate and Trust Administration. So you can't make that up. It's just the way it worked out.
That's perfect.
Yeah, it is. So that's actually one of our most popular presentations because there's just a lot of questions that need to be answered about that and understanding the process. On Monday, the 26th, we'll have Lily Hummel, our principal attorney at the Rockville office. She'll be in person at Friends House Retirement Community. That is down in Sandy Spring by Rockville, talking about Let's Talk About Your Legacy, a discussion about wills and advance directives. And that's open to the public. I'll send information out about that. And last couple I'll mention, then we'll wrap up. Wednesday the 28th, trustee selection and how to choose the right one for you. Shannon touched on that today. Always one of our more popular quarterly presentations. And lastly, we have our guest presenter from Main Street Home Loans, mortgage advisor Marie Ritzenberg, back for her third part in her, for now, three-part series, Planning for the Future and Using Real Estate as a Vehicle. And just posted some information about that, and we'll send out some information for you about that in my follow-up message. So appreciate you being here today. Shannon, thanks again, and we'll see you again soon on the Elville webinar series. Have a great day, everybody.